When government breaks the law. That's the topic of today's Bold and Blunt, and I'm your host, Cheryl Chumley, giving you a Christian conservative look at today's news, politics, culture, and events. We know what happens in America when American citizens break the law. But what happens when government bureaucrats break the law? Frequently, nothing, and that's cause for concern. Before I get into all that, I want to give a quick heads up that if you are already a subscriber to Bold and Blunt, thank you. If you're not a subscriber to Bold and Blunt, I would ask, please subscribe. You can do so by going to WashingtonTimes.com, scrolling to the bottom of the page where it says newsletter section. Click on my name there, Cheryl Chumley, and you can sign up to my 3 times a week newsletter that contains all my commentaries that I write all day long at the Washington Times, as well as my twice weekly Tuesday and Thursdays Bold and Blunt podcast. Love to have you aboard. But also, you can also get Bold and Blunt by subscription anywhere podcasts are offered, including the #1 platform for faith-based podcasts in the United States. It's called Edify, and you can find it at edify.app/podcast. Go there, check out all the faith-based podcasts, sign up for the ones you're interested in, and I hope and pray that you might find interest in Bold and Blunt, which is now featured there. So, governments that break the law, government bureaucrats who break the law, what happens to them? In America, we have this concept of justice being blind, and we all know that that is really the goal, but it's rarely, if ever, met. Justice is far from blind. Black Lives Matter sprang out of that concept. You can agree or disagree with Black Lives Matter. I happen to disagree with their methods. I happen to disagree with their communist roots, and I happen to disagree with how they spend their money, which is an interesting topic in its own, because so many of the millions donated to this group have magically disappeared. But Black Lives Matter did spring out of the notion that there were unfair practices going on in the world of America's judiciary. And there is some truth to that point. Just because we don't like the messenger doesn't mean that we should completely throw out the message, right? Because after all, in America, our striving is for God-given individual liberties for all, not just certain segments of society, not just the rich in society and well-off in society and well-connected of society. And in this show, not just the government bureaucrats of society. The Institute for Justice, you can find it online at ij.org. It's a nonprofit, and I like so much of the work they do because it's all based on advancing the principles of the Constitution, regardless of partisanship. Because really, the Constitution is supposed to apply to all of us. It's not supposed to apply to Republicans versus Democrats. It's not supposed to be seized upon as a campaign issue by conservatives versus liberals. It's supposed to apply to all of America. And again, the concept of American exceptionalism as put forth in the Constitution comes from the idea that individual rights come from God, not government. And these individual rights apply to all, regardless of party. So I love organizations out there that advance principles over party. And the Institute for Justice has this report and this project about qualified immunity. And they question, where is the accountability in that concept? And let me read you right from their issues page. The Institute for Justice's project on immunity and accountability is devoted to a simple idea. If we, the people, must follow the law, our government must follow the Constitution. That's great. That's a great sentence. That sums it up aptly, doesn't it? Justice is blind in America. There is no class society in America where the law applies to some, but not to others. And as Institute for Justice writes, we have a lot of work to do to turn that idea into reality. A web of legal doctrines effectively places government workers above the law by making it nearly impossible for individuals to hold them accountable for violations of constitutional rights. Outside of narrow exceptions, these doctrines give all those employed by the government, police, mayors, school officials, IRS agents, you name it, immunity from lawsuits, even if they act in bad faith. Okay, end quote there. Did you know that? Maybe you did. But maybe it's time, if you did, to rethink the concept behind that. Because why should certain segments of society be removed from the normal judiciary process, the normal blind justice concept that the rest in America have to abide? Now, I know in conservative camps, it's all about supporting police, right? I know that conservatives rarely want to go on record questioning police, questioning law enforcement, because after all, conservatives have become the segment of American society that embraces law and order, whereas liberals, Democrats, the Socialist Democrat Party, the outright communists in the Democrat Party, have become the group in society, in American society, that wants to defund the police, wants to rip up the Constitution because, as they claim, it's rooted in racism and therefore deserving of replacement of some other government system. I know that conservatives always want to side automatically with police when any story pops or crops in the news involving, say, police brutality or police shootings of citizens. And that's well and good. It's well and good to support police, and I support police 100%. Law and order in this country must go forth, and police are a crucial line in that battle that cannot be crossed. But police, you have to remember, just like teachers, right? They're still government employees. And one bad apple in a tree of fruitful apples is still a bad apple that needs to be addressed. And when it comes to qualified immunity, when it comes to granting automatic immunity from prosecution, from lawsuits to certain government bureaucrats over private individuals, when you automatically grant exemptions for government bureaucrats or government employees, public servants, at the expense of the private citizen's ability to pursue constitutional claims against these public servants, it creates this imbalance in law and order in itself, right? You can't have blind justice. You can't have law and order while you are actually elevating one class of society above another and preventing one class of society from pursuing legal redress through the court systems against another class of society. Police are wrapped up in this immunity exemptions, right? They're wrapped up in this immunity process, and it's not always for the good of society. It's not always for the good of law and order. Let me read you this piece from The Hill. Calls for an all-out ban on the execution of no-knock warrants by law enforcement in Minneapolis are intensifying following the police killing of Amir Locke, a 22-year-old black man, by a police officer during a recent raid. But some advocates and legal experts warn a blanket ban may not be enough to avoid such tragedies. Look, no-knock warrants are basically when the police have received a warrant to arrest somebody where that somebody is inside a residence and the police have been given permission, been granted a judge's okay to enter that person's home or location, facility, without having to wait for the door to be opened. So they can storm right in. They can storm right into your home. And by and large, police say they need to be able to do this because, say, arrests made of drug suspects are inherently dangerous because these drug suspects may be well armed and they may not hesitate to shoot at police. So for the safety of law enforcement, the ability of law enforcement to execute these warrants in a safe manner, in a manner which surprises the suspect so the suspect can't come out guns a-blazing, is a crucial protection for police. That may be, that's a sound and sensible argument, but the bigger question here, is it constitutional? Is it constitutional for police to just barge into a private citizen's home to hand over an arrest warrant, to execute an arrest warrant, to arrest the individual? I say no. And there have been instances in the past where individuals have died because police have shot those people in the home who have been surprised by the police's presence, maybe in the dead of night, and because they're surprised by somebody breaking into their home. In their views, their home is being broken into. They grab their gun and they go out and brandish their weapon at the police, not knowing that these are police, and the police have shot them because in the police officer's eyes, they're protecting the police officer. So no-knock warrants by law enforcement are decidedly unconstitutional, and yet they have morphed into something necessary for police to have, for law enforcement to have, based on arguments that police need to side with safety first and Constitution second in this particular matter. I disagree, but it's an area where police are protected from prosecution by individuals impacted adversely by the service of no-knock warrants, by the survivors of family members who have been killed by no-knock warrants. So this is one area where the balance is decidedly for one segment of society versus another, over another, where the police are handed special protections above and beyond what the Constitution allows, over that of the private citizen, over that of the private citizen's right to be safe and secure in his or her home, as the Constitution underscores. Look, these aren't just interesting legal questions. They're not just questions for law students to banter about with their professors in law school. These are matters that impact every American's lives, because even if you're not impacted by, say, a no-knock warrant, or even if you're not impacted by a bureaucrat who has claimed immunity from lawsuit and therefore you can't pursue your case in court, it's the overall state of America's Constitution that impacts all. So when individual rights are chipped away in certain areas, whether by no-knock warrants, the service of no-knock warrants, and the constitutional offense that those bring, or by qualified immunity and the constitutional offense those brings, a chip here, a chip there, it affects the entire system, not just the individuals. So I have with me today a woman from Institute for Justice. Her name is Anya Bidwell. She is an attorney with the Institute for Justice, and she's an expert on immunity. She is actually one of the leaders of Institute for Justice's Project on Immunity and Accountability, and she's here today on Bold and Blunt to help flush out some of the reasons we all need as American citizens to be concerned going forward about this issue of qualified immunity. Anya, thank you so much for being on Bold and Blunt. I really appreciate your time.
Absolutely. It's a pleasure to be on.
So Institute for Justice has this new report that caught my attention. It's called 50 Shades of Government Immunity. And can you kind of tell people what the report's about?
Absolutely. The report grades state laws based on how easy it is to sue for violations of individual rights under state law, right? We all know about the barrier of qualified immunity that exists under federal law and how difficult it is to overcome that barrier when you want to sue any government official for violations of constitutional rights. So we decided to go to states and see what they offer as an alternative. And we grade states based on how widely they open this courthouse door. So, for example, if you have a claim against a police officer, right, for using excessive force, you could either go to federal court and sue under the Fourth Amendment using Section 1983, the Civil Rights Statute, or you can actually go to state court, theoretically speaking, and sue there either under a civil rights statute or under a tort statute, a personal injury statute, right? And so we wanted to kind of see how easy it would be to do it there, whether you have similar barriers to qualified immunity, and whether, there's anything that state lawmakers, frankly, can do now that they are back in session to improve their laws and make them better.
So give a real layman's definition of qualified immunity so everybody's on board.
Sure. Qualified immunity is a defense that government officials can use right at the outset of the litigation, right? As soon as you file your complaint. And they basically say, I have qualified immunity, you can't sue me. And then the burden is on you to basically find a case in your jurisdiction's appellate court, federal appellate court, or in the United States Supreme Court that basically specifically says that the very violation that happened to you, a court already proclaimed to be unconstitutional. And if you don't have a case like that, what generally happens is your case gets thrown out before, fact discovery can even begin. And what's ironic about this doctrine, right? Well, first of all, it's nowhere to be found in the history of this country. But another thing, too, is that the more outrageous and unconventional the violation, the less likely it is to be found in case law, right? For example, there is a case in California involving police officers stealing money. There isn't another case about police officers stealing money anywhere else in the Ninth Circuit. So qualified immunity protected those officers because nobody was, bold enough to do that before. So qualified immunity adds up to being almost an insurmountable barrier when you sue for violations of constitutional rights. And the Supreme Court, as well as Congress, they kind of so far have not been willing to weigh in and make that barrier a little less difficult to overcome.
Here's one of the things I don't like about it, and you can tell me if I'm wrong on this, but it sort of sets the stage that there are two classes of society. One who has, irrefutable constitutional protections, and another class that sort of has constitutional protections, but under some circumstances, those can be taken away. Am I wrong in interpreting that?
I would say that it really shows there's essentially two classes of people, as you mentioned. One class is government officials, right, to whom the law doesn't apply. And the other class of people are regular citizens, right? There's always this idea that ignorance is not an excuse, right? That, citizens must obey the law. And that's true, and that's how courts look at us when we conduct ourselves. But when it comes to government workers, they're a special class of their own where
See, that's maddening because the government officials are supposed to be our public servants, which if anybody has an elevated class, it should be the citizens, yes?
Oh, absolutely, absolutely. And you remind me of one of my clients, Cassie Polrees. Her children were walking home from grandparents' dinner, and this police officer, was looking for two fugitives on the run. And these two kids, they were just walking calmly, hands swinging at their sides. One was 12, one was 14. And the officer somehow thought that they were suspects, right, and held them under the gun and handcuffed them. Cassie came out. She told him, they're my children. You could hear their voices. They speak like children. And yet the officer held them at gunpoint for 8 minutes, even though he knew that what he was doing was absolutely inappropriate. And Cassie, she wrote this beautiful op-ed in the USA Today, and she talked about how she grew up to revere government officials and think that they are the ones who are supposed to know better, right, and have kind of a deference for them. And now she's basically saying, how come that this police officer is not being even held to the same standards that I am being held to? That somehow this clearly unconstitutional behavior actually is not, he's not being held accountable for it. The claims by her children were actually dismissed on qualified immunity grounds. So that exactly is that double standard between government officials, and not just police officers, any government official, and a regular citizen.
Now, the other side would probably say they need qualified immunity in order to prevent frivolous lawsuits, right? People who just go after government officials because there are big pots of taxpayer dollars that can be won in judgments. Is that a valid reason to resist?
No.
Okay.
No, it's not a valid reason. There have been numerous studies done about this. Joanna Schwartz, a law professor at UCLA, she's probably the most prolific author on this, where, she actually looks at all these different cases and tries to evaluate whether qualified immunity actually, meets this stated goal. And what she finds is that constitutional claims in general are extremely hard to allege, right? If I go to court, if I'm Cassie Polrees and I sue on behalf of my children for violations of their Fourth Amendment rights because the officer held them at gunpoint for no reason, right? I have to show that the officer acted unreasonably, right? And showing that element of reasonableness is extremely difficult. The U.S. Supreme Court on numerous occasions said that when it comes to violations of constitutional rights, especially the Fourth Amendment, split-second decision-making, we will never second-guess officers acting in these kind of circumstances, right? So that by itself is extremely difficult to overcome. And you certainly don't need qualified immunity for that. That's just an extra barrier. There was another study that Joanna did, and she found that qualified immunity really is being used in only 4% of the civil rights cases, right? And what that shows is that when it comes to frivolous lawsuits, you don't even need qualified immunity to come in, right? It's really difficult to state a constitutional claim. There are already federal rules of civil procedure that require appropriate pleading. So it's extremely difficult under the rules as they work today without qualified immunity to file a frivolous lawsuit. Qualified immunity really only kicks in when the government has no other arguments left to use, right? When you actually have a clear case of constitutional violation, a meritful case of constitutional violation, that's when qualified immunity kicks in, and that's when very good cases get thrown out on procedural reasons before we can even begin discovery process.
So how did we get here? How did we get to this situation in America now where there's so much qualified immunity protections at the states and federal levels?
That's a great question. Qualified immunity is not consistent with this country's history, right? It's a doctrine. Its current iteration is invented by the United States Supreme Court in 1982 in a case called Harlow versus Fitzgerald. It didn't even involve police officers, right? Those were desk-bound bureaucrats serving in the Nixon administration, retaliating against someone. Really, this serious crackdown on individual remedies began in 1982 and is continuing till this day. And what often experts attribute it to is this important civil rights case, Monroe versus Pape, from the early 1960s that allowed constitutional claims to be filed in federal court under a broad set of circumstances. So Monroe versus Pape, in a way, allowed many more constitutional claims, opened the courthouse doors broader. And so it could be that the Supreme Court was very much concerned with there just being too many constitutional violations. But the idea that there are constitutional violations, too many of them, doesn't mean that they are frivolous, right? It's just you actually have a lot of good faith constitutional claims coming in, and the Supreme Court sort of started to limit them very much on policy grounds, right? And that's kind of also important to understand. Policy is the purview of Congress and state legislators. Policy is not the purview of courts. Courts are supposed to look at the law and determine whether the law was violated. But the court did use policy grounds, like the being worried about frivolous lawsuits, as we discussed, to create this doctrine. And, as the events of the summer of 2020, the murder of George Floyd, have shown, it is time for us to turn the dial back, right, and start opening the courthouse doors again.
Okay, so you bring up George Floyd, and I was just about to ask you that the current climate that America's in right now, with all eyes turned on police, the defund the police movement, and so forth, how has that impacted states where they're leaning on changes to qualified immunity?
The states, at least some of them, like Colorado and New Mexico, California, New York, they've been working hard to open an alternative courthouse door, right? To say that, maybe qualified immunity prevents federal lawsuits, but you can come to us, you can come to state courts, and we're going to make our courts more accessible. So that's what we're generally seeing. New Mexico, in particular, gets the highest grade from us because it not only gets rid of its own version of qualified immunity, but it also allows not just police officers to be sued, it allows any government worker to be sued, right? And as we discussed, at least with police officers, we're talking about split-second decision-making, right? With a lot of other government workers, there is plenty of time to figure out what to do and commit a constitutional violation. So there's even less reason. So we are optimistic that states are moving in that direction. We're hearing, Maryland and Virginia and many other states are kind of, New Hampshire are working towards reforming their laws and not waiting for Washington, D.C., because, frankly, it looks like, they are stuck and can't do anything, as the Justice and Policing Act experience showed over the past year.
Do you have time for one more question?
Absolutely.
Because I'm curious, what is the most egregious example that you can give of a government official receiving qualified immunity. Because as you rightly point out, police are in situations where they make life or death decisions on a dime, right? They have to do it in that split second. But what government bureaucrat is out there that is receiving qualified immunity right now that it's so ridiculous it defies all logic?
Well, frankly, the case that created qualified immunity in the first place, right, I think is a great example. Harlow versus Fitzgerald. And that involved two Nixon administration aides. They didn't like this whistleblower who was testifying to Congress publicly about the Defense Department overruns when it comes to a particular weapon program. So they decided to punish him and fire him for speaking out. And that really is a very clear violation of the constitutional right. Everybody knows you're not supposed to silence somebody who is testifying before Congress. And, the court actually thought that it would be a good idea to use those facts and that case to provide government officials with qualified immunity. I have a client, Sylvia Gonzalez. We are currently in the Fifth Circuit fighting qualified immunity. She championed a petition to fire a city manager in Castle Hills, Texas. City manager happens to be friends with the mayor and the chief of police. So they basically threw her in jail. She is 72-year-old grandma, right? And they threw her in jail to punish her and to scare her from not attempting to fire the city manager ever again. And what do you know? They immediately claimed qualified immunity the second we filed that lawsuit. And now everything is basically stopped in its tracks, and we are in the Fifth Circuit Court of Appeals without being able to proceed to discovery, trying to convince that court that everybody should know you're not supposed to be throwing grandmas in jail just because they're speaking out against their city manager. And qualified immunity is remaining a barrier. We are hoping for a favorable decision there. But again, you don't have a split-second decision-making there, just like in Harlow versus Fitzgerald with those two Nixon aides. There is no high-intensity situation of any kind. It's just trying to silence somebody for speaking their mind.
Yeah, that's not just a constitutional offense. That's just bad optics. I mean, that's the height of government arrogance right there, to toss a 72-year-old woman in jail to scare her. Well, you know what? Thank goodness for the Institute for Justice for covering this, because between qualified immunity and civil asset forfeiture, honestly, I don't know how Americans have civil rights left. So, Anya Bidwell, I want to thank you so much for being on Bold and Blunt and explaining this issue.
Thank you so much for having me, Cheryl.
So what do you think? Do you think it's important that government bureaucrats, the public servants whose salaries we pay, should receive extra constitutional protections that the rest of us in America don't? It's not just something to think about, but really it's something to revisit as policy. Because in this country, if our rights come from God, not government, anything that waters that concept is worthy to revisit and possibly change. I want to thank you for listening. I want to remind you also that you can get Bold and Blunt at edify.app/podcasts, the place for faith-based podcasts, and also at the Washington Times. Love it if you would subscribe to my newsletter, if you're able to do that. Appreciate it. Appreciate your support. And you know what? The Washington Times thanks you for your support as well. Tune in next time. And don't forget, in the meanwhile, stay blunt, stay bold.